Good morning, Lee and Richard. Today is November 15, 2016. I want to talk about inference of intent. That's a subject that we talked about to a small degree last week. I would suspect that once the DA's office recognizes that it is now out in the open that vicarious liability is not a legal theory, is not a viable legal theory, in this case, simply because the Court of Appeals doesn't allow it, doesn't recognize it, they will then fall back upon inference of intent. And Lee, you mentioned that when you met with Greg Pavlidis last week or 2 weeks ago, that he mentioned to you that inference of intent was a legal theory they perhaps would rely upon. It is recognized in this case that my handwriting, my initials, my blueprint, my palm print, nothing here bears any connection to me other than the fact that Stetch was using my name, and I did sign checks for legal fees, and I did authorize the payment of legal fees, and perhaps certain other miscellaneous checks were signed by me. But please bear in mind that if you look at the forensic analysis, there are 3 checks only which they are attributing to my signature personally, and those are checks for attorney fees. And that's my recollection, that I signed checks for attorney fees and nothing else. Now, inference of intent. What they're going to say, likely, will be that even though no document has my palm print, even though I was not personally involved in these transactions, even though I was not present at any of these paper signings, even though that everything points to Stetch and the folks that work for Stetch, they will say, court, jury, infer that he had intent, that he had an evil mind because. And now we have to fill in the blanks. What the law says, and now I'm referring back to People v. Churchill and People v. Ryan, you will find both cases at length on the website under New York law. People v. Churchill, People v. Ryan, they say that the law in this area, as per the Court of Appeals, is that they must show that there is no evidence of any that points to guilt. And the buzzwords that are used is that to a moral certainty exclude every hypothesis other than guilt. Now those are big legal words, so let's break it down. To a moral certainty. All right, well that sounds like it's a high degree of proof. No hypothesis other than guilt. Well, checks. Can you look at a check and say, no hypothesis other than guilt? Might a check be written for a legitimate purpose? Let's put it in context. We have an office calendar. I've indicated several times that we would look at the office calendar, see if a closing was on the calendar, if it was a short sale, and if it was, I get paid. If it says bank, I get paid. We relied upon the statements of Stetch. I had Camille, a male, a paralegal, well, you can call him a paralegal, he's more of an administrative person. He worked in the office. He would go to Stetch and say, Stetch, did it close? Yep, Camille, it did close. Great, check is issued. That's as far as it went. I didn't review any files. I didn't review any HUD ones. I entrusted everything to Stetch because if Stetch said it closed, I believe what she had to say. Didn't go beyond that. So, exclude every hypothesis other than guilt. Well, we had an office calendar, and we issued checks based upon an office calendar, and we were a law office, and we did charge for our services. And the fees that were paid were very much commensurate with fees either in a short sale or pursuant to a bank closing. I would have no idea what her HUD ones said, and there is no doubt that her HUD ones were fraudulent. They didn't have any information that was accurate, but then again, I didn't do the HUD ones, I didn't sign the HUD ones. She often did, or the folks that worked for her signed the HUD ones. Now, what about all the documents that were submitted to a bank in connection with a short sale? Does that exclude every hypothesis other than guilt? No, because in all the short sale closings, that's what was done. Documents would be submitted to a bank to obtain approval on a short sale. That is very much in the normal course of business. What about documents submitted to get a short sale done after her paper signings. Well, I would have no knowledge as to when the closing occurred and put that in the context of documents that were submitted to banks. That was her thing. So that doesn't apply to me since I wasn't involved. I wasn't reviewing that. So how does that exclude every hypothesis other than guilt? Doesn't say that I was involved if it doesn't have my palm print. It doesn't have any indicia that I was involved. Now, what else may exist? What else can be important? Well, the DA's office had every opportunity to take a look at all those documents, take a look at the handwriting, and determine, did Ken Schwartz's handwriting appear in any of those documents? They had me there. We voluntarily, remember Richard, we went down to the DA's office. I voluntarily submitted to all of this forensic analysis. They asked me to sign my name. I did. And what they did was they tested my signature against checks and checks only. They did not test my signature against any of the documents that were submitted to banks, any of the cease and desist letters that Stetch issued, because the accusation is not being made against me that my signature appears on those documents. But please keep in mind, if they wanted to, they had every opportunity to take a look at the handwriting that appeared in all of those documents. I would suspect thousands of pages, and to determine whether or not they had a match against my handwriting. They chose not to do it. Well, what about all those witnesses that she paraded before the grand jury? Did anybody say that I was involved? No, they said Stetch was involved. Talked to Bassi, Das Ramos, Bardalis, and whoever was there. Jose Mateo, they said they dealt with Stetch. Wright was very crafty. She never asked the question, did you ever deal with Schwartz? Ever speak to Schwartz? Schwartz ever give you anything? That never happened. So the evidence has been confined to dealings with Stetch alone. So how do you get from that an inference of intent? Exclude every hypothesis other than guilt. That's guilt as to me, not as to her. Exclude every hypothesis other than guilt as to Schwartz. Well, they dealt with Stetch, not Schwartz. Could it be that Stetch acted without telling Schwartz what she was doing? Could it be that Schwartz didn't know what she was doing? Could it be that if you look at the office calendar and you see, and there's a separate section, which I'll do in a few minutes, on office calendars, could it be that the office calendar correctly stated that Stetch and Stetch alone was having all of these meetings, events, contacts with folks that were involved in all of these illegitimate transactions? So you can see that under the law in the state of New York, as per the Court of Appeals, People v. Churchill, People v. Ryan, and there are other Court of Appeals cases, there is no doubt the DA's office cannot satisfy the burden which the law imposes upon them. No hypothesis other than guilt. To a moral certainty, exclude every hypothesis other than guilt. That's not realistic. It's frivolous. It's meritless. They brought this case, and they're hoping to obtain something which they know they're not entitled to. Thank you, gentlemen, for listening. That's what we need to concentrate on. Bye-bye.